Hi, my name is Carl Pearson. I'm a Harvard lawyer, a New York attorney, and I represent homeowners and small businesses throughout the United States in foreclosure defense litigation, quiet title actions, wrongful foreclosure actions, and all of that customarily is to make the mortgage more affordable with a loan modification agreement, including a principal reduction, hopefully. This video is number 111, that is 111-I, entitled Defending Foreclosure Actions, and it's the 9th in a series of 12 related videos. The 12 videos are being prepared for viewing in sequence from A to L and provide an up-to-date look at defending foreclosures. Preliminarily, I want to say that there are two types of foreclosure methods in the United States. One is where the mortgagee or its agent, which we know as a servicer, has to file a foreclosure action in the state court for the county or in the county where the mortgage property is located. This happens in the 22 judicial foreclosure states, in which New York and Florida are the two most important. The security instrument that's used is called a mortgage. The other method is a non-judicial foreclosure, which takes place in 28 states, the most noteworthy of which is California. In a non-judicial foreclosure, title to the mortgage property is conveyed to a trustee, which company, usually, or person, holds title in trust for the benefit of the owner or holder of the note. This trustee is not the same as the REMIC trustee, which came into being with any securitization of the loan. Make sure that you know the difference. The first trustee is created at the moment the mortgage loan was made. Instead of a mortgage, the security instrument is called a deed of trust, and the trustee is usually a local entity whose business is to be a trustee under such deeds of trust. When analyzing a foreclosure situation, I have a few concerns that I want to discuss with you. One, whether there is or has been any litigation at all. I want to know everything that happened because there may be issues that have already been decided and cannot be raised again. The remedy may be to vacate a prior judgment instead of taking any other kind of action. Two, was there any bankruptcy, or is the homeowner considering bankruptcy? If the homeowner is in bankruptcy, there was an automatic stay granted at the filing of the bankruptcy, which stops all litigation, and because the homeowner is in bankruptcy, there may have to be permission obtained from the court to engage in state court litigation, and this may also be true even if someone else is paying your litigation expenses in state court. Three, when a homeowner files for bankruptcy to obtain a stay of sale of the home in a non-judicial foreclosure state, the bank will probably move to vacate the stay and obtain an order vacating the stay within several weeks, so the relief to be obtained through bankruptcy filing is often quite short and not worth the trouble. Instead, the homeowner should have been defending the foreclosure action or filing an action in state court to stop a judicial foreclosure. Now, I want to make a point here which should have been put in elsewhere, but with a quiet title action, hopefully the homeowner, at most optimally, should keep paying the mortgage if he or she can, so that there can be no reprisal such as a foreclosure sale during the time that the quiet title action is pending. So that doesn't fit in here exactly, but just remember that point. 4. A foreclosure action is started when the bank or servicer for the bank files a complaint in foreclosure and then serves a copy of the summons and complaint on the homeowner and others. The John Doe defendants are whoever may be occupying the property, such as tenants or relatives, or others with a claimed interest in the property. Generally, but you should be guided by the summons itself, there will be 20 days or longer in which to answer the complaint. An answer is not where the homeowner shows up in the clerk's office on the last day and says that he or she is there to answer the complaint. Instead, the answer is prepared in advance by an attorney retained by the homeowner and hopefully not done without attorney's help on a pro se basis. and the answer will consist of responses to each paragraph in the complaint, denying some of the allegations, and then adding affirmative defenses to the lawsuit, such as standing or failure to serve the summons properly, and then should end with meritorious counterclaims against the plaintiff, bank, or servicer, assuming that there are such. 6. It is important that you retain an experienced attorney and not try to do this yourself to save money. The saving will probably cost you your property. On a statistical basis, the likelihood that you can prevail as a pro se litigant is not very good. 7. There are perhaps 20 to 30 affirmative defenses for your attorney to consider, including the most common one in all litigation, which is failure to state a cause of action, and the affirmative defense of lack of standing, or another one such as statute of limitations. These defenses need to be identified by the attorney through looking at the full record of any prior court actions, the documents on file against the property in the county clerk's office, and any securitization audit. The lack of standing issue covers a lot of ground, including invalid documents where invalidity was caused by robo-signing or outright forgery or unauthorized changes made to the note or mortgage or deed of trust, as well as the lack of any assignments of title. Also, in many jurisdictions, there are issues of whether MERS has a right to make assignments of title to mortgages. 8. Also, your attorney should be able to put together various meritorious counterclaims, such as a declaratory judgment that the plaintiff, servicer, and the bank that it represents do not hold the note and have no title to the mortgage. This can get rather complicated because the note is probably negotiable, and the Uniform Commercial Code deals with a note and mortgage more as a security, such as a stock or bond, than as a mortgage or document relating to real property. 9. The counterclaim should, when appropriate, if they prevail, eliminate any interest of the bank and servicer in the note and mortgage, which is why the related action and the counterclaim are often referred to as, quote, quiet title, unquote. It really is not intended to cancel the note and mortgage, but merely to obtain a court decision that the plaintiff, servicer, and the bank, which is a REMIC trustee it represents, are not the lawful holder of the note and authorized servicer for the lawful owner. 10. Homeowners throughout the country are under the false impression that a quiet title action or defense has a good chance of letting them eliminate the note and mortgage and keep the house for nothing. 11. This is not going to happen in 99,999 times out of 10,000, out of 100,000. It is very rare, and it would take far more in legal fees to go up against the bank long enough to obtain this result, if it is obtainable at all. Instead of trying to get the home for nothing, the counterclaim, quiet title, is an effort to get the bank to give the homeowner a reasonable loan modification and hopefully a principal reduction to enable the homeowners to stay in the property. If this takes place, the homeowner is a winner, and I might add the bank as well, because it gets the property back to performing status as a loan. 12. The problem which homeowners face with loan modification agreements in settlement of the foreclosure action and quiet title counterclaim is that if the property is underwater and there is no corresponding principal reduction, the homeowner is being given a near worthless option of paying the mortgage for 30 years without any hope of obtaining equity. In such cases, the homeowner is probably better off not taking the loan mod offered and seek discovery to try to show that the bank and servicer are not the right persons to enforce the note and bring a lawsuit or foreclose on the property. 13. If this evidence is obtained, the homeowner can move for summary judgment dismissing the foreclosure action and perhaps obtain an order that the plaintiff, servicer, and REMIC trustee it represents do not own or hold the note or mortgage, which might give reason for the plaintiff to reconsider its failure to give a proposal and then provide a better deal for the homeowner as a reasonable loan modification agreement. 14. The homeowner is more apt to get a favorable loan modification agreement if he or she is in court against the servicer and bank than if not. The bank is under greater pressure to give a reasonable loan mod if there is litigation to be ended, because litigation is costly and the cost of litigation to the bank could exceed the value of the mortgage property. 15. Foreclosure actions have a new feature in many states, such as in New York, New Jersey, and Florida. They involve mandatory settlement conferences with a servicer or bank to try in good faith to negotiate a loan modification agreement. If the bank fails to provide a workable agreement, there could be an additional defense under state law, such as in New York, that the bank failed to negotiate in good faith. In New York, the homeowner's lawyer would request a good faith evidentiary hearing, and if the homeowner prevails, the foreclosure action could be dismissed with prejudice for the bank's failure to negotiate a loan modification in good faith. But that doesn't mean it has to grant one, it merely has to negotiate in good faith. 16. A foreclosure action should be viewed as a great opportunity to obtain a loan modification agreement rather than the threat of loss of the homeowner's property, if the foreclosure action is defended properly and timely, and if the homeowner in fact has the financial capability of making payments on a reasonable loan modification agreement. 17. Here's something I want you to know. Most of the defenses that we can raise against foreclosure are temporary. A foreclosure action cannot be amended once it's brought in order to change the basis upon which it was brought. That's a no-no under law. Thus, if the bank didn't have good title when it commenced the action, you could defend the action and get it dismissed for lack of standing. But this lack of standing could and probably would be cured by the bank. The bank would merely have to go back to the right people under law to obtain the proper documentation for title, and then file another foreclosure action against you, if it isn't barred by the statute of limitations. So remember that the bank can correct these problems and sue again, but they cannot file a new action after the statute of limitations has expired. New York has a 6-year contract-based statute of limitations, and a bank cannot commence a new foreclosure action more than 6 years after it gave notice of acceleration of debt and intent to foreclose to the homeowner. 18. Finally, when faced with a foreclosure action, obtain competent legal help right away, without delay, and you have the best chance of saving your home. I can help your attorney provide the legal services you need, if he needs it, in any state of the country, which could make it easier for you to find a local attorney. If you can't find a local attorney, I can do that for you, subject to your approval. Remember, it's number 19. Don't let your foreclosure opportunity slip by. Get help. Save your home. At least you have a significantly better chance of doing so when you have experienced legal services and you're in a litigation. I'm finished with defending foreclosure action video, and you should go on to my next video, 1112, that is number 112J, quiet title actions, which applies in all 50 states, but be careful, only 28 of them are the non-judicial states in which a quiet title action would arise. So if you have any questions, please give me a call. My telephone number in New York is 212-307-4444. I provide free consultations and represent homeowners and businesses throughout the United States as to their foreclosure problems, including the saving of properties through loan modifications and any principal reductions. But remember, there's never any guarantee whatsoever in litigation. You never know what's going to happen. My number again, 212-307-4444.